Thank you everyone for joining in. My name is Vishal Sharma, and I'm the moderator for today's session. Today I'm joined by Prashanthi Reddy. Prashanthi is having a great background in the field. She is a graduate from University of Pennsylvania Law School in 1996, so it certainly has been a while that she is in the field of immigration since 1997. She's admitted to the bar in New York. She's a member of the American Immigration Lawyer Association, as well as the New York Bar Association. And alongside, she also is immigration chair for the National South Asian Bar Association and immigration co-chair for the Federation of Indian Associations as well. She's currently actively involved in pro bono legal work. And on that note, I'll pass the controls to you, Prashanthi.
Yep. Okay, let's start our session today. I think there's a lot going on in the immigration field, especially in the H-1B field. I thought we'll start with, some news about the second lottery. I think that's kind of like breaking news. Everyone is wondering what's happening in the H-1B space. So I thought I'll just give you a short synopsis of what's going on with reference to registrations this year and why we had a second lottery and what are the expectations for a third lottery, if any. So just to start off with, we all know that there's been a significant increase in registrations this year. USCIS reported 780,884 registrations, and that's an increase of 61% from last year. So if you look at the table that we have, it shows, paints a picture of what's happening this year. Percentage of eligible H-1B registrations. As a result of the large number of registrations, obviously, the eligibility has decreased significantly from last year to this year. But this table doesn't reflect the second lottery. So with the second lottery, the 14.6% has improved slightly. I think it's gone to about 20-something%. But still, if you look at 2021, the percentage of registrations that were selected is almost half, and then decreases every year, as you see, 2022, 43%, 2023, 26%. So you see it's been decreasing every year because I guess the registrations have been increasing. And also there's this whole issue about duplicate registrations. Let's go to the next slide. So if you look at increase in eligible H-1B registration with only one employer. So if you put the duplicates aside, and if you look at that, we know because of the duplicates, it's about 700,000. But without the duplicates, it's still increased. If you look at 2022, it was 211,000 registrations, and this year it's 350,000 single registrations. So with all this hype about duplicates, yes, that is definitely a reason for increase in registration, but also the increase in demand. As you see, there's an increase of 138,000 odd numbers since 2022 to 2024. Next slide. Now, with reference to the duplicate registrations, of course, some are duplicate registrations because the beneficiaries have filed, 5-10 registrations, and that's allowed by USCIS. There seems to be this misconception that no duplicate registrations are allowed, no beneficiaries are allowed to file multiple registrations, but employers, of course, are not allowed to file more than one registration per person, but also they cannot collude with other companies and get together and file, for the same group of people. So collusion is not allowed. And it seems that a lot of collusion has occurred this year, much more than last year. And USCIS is basically blaming a small number of employers, and most of these are startup employers, people who have not really filed H-1s before. So they must have done their research, and they're saying that a small number of companies are responsible for entering the same applicants into the lottery multiple times, and colluding. So and I've seen this as well, startup companies who've not filed a single H1s, filing hundreds of applications. So there's obviously fraud in there. And they have not actually filed the H-1B petitions. They're only filing registrations. So there is a lot of fraud involved, and we all know that. And USCIS is going after these companies. So what is the solution to this problem? Now, even though we're looking at all these issues with reference to registrations and multiple registrations, and the fact that really registration system, the whole system didn't work this year, I think what the real problem here is that there remains a low annual H-1B limit. So the H-1B limit is only 85,000, and that is really not enough for the demand, really. We just saw in the previous table that there were 350 eligible single registrations. So the demand has increased, from 265,000 last year. So that means even if you don't, if you ignore the multiple registrations, everybody seems to be blaming the multiple registrations for the situation we're in now, but it's actually the low H-1B limit and the high demand. So even if we ignore that multiple registration, only 25% of cases would have been picked. That's a really low number. So it's something that has to be done by Congress to increase the number of, H-1B numbers. I think that's the main problem. Also, just a reminder that, because of all this, obviously, we've had a second lottery now. And the second lottery, we have a 90-day period to file the H-1B petitions under the second lottery. So that brings us really to October 31st. It was the same as the first lottery. They gave us 90 days, and the same thing they do that as well for every lottery. So they give us 90 days. So you have to file before October 31st. Some people are asking me if they can file the first lottery H1s now because they didn't file, or they couldn't file. They think that because the lottery is open again, you can file cases for both the first lottery as well as the second lottery. That's not the case. This 90-day window is essentially only for the second lottery. So those cases that are picked in the second lottery, only those cases can be filed. Next slide, Vishwa. So what are the chances of having another lottery, a third lottery? Again, this question is asked. Again, we have no definite answer because, we can't look into the future, and we don't know how many H1Bs will actually be filed based on the registrations that have been selected. So let's see. But, a point to note is that USCIS has selected the highest number of H-1B registrations this year compared to any other year. 2022 was 131,000, now it's 188,000. And this tells a story by itself that registrations are being selected, but cases are not being filed because the whole scare of duplicate registrations, and also because some companies have only filed for the sake of filing registrations, and they had no intention of filing the actual H1. So because of those problems and because of USCIS kind of giving notification, sending out notifications that people with multiple registrations or other companies who have colluded will be taken to task, and they will be, investigated for fraud, etc. A lot of companies have not filed. Companies who have done collusion have not filed their H1s, even though they have registered. So based on all this and the fact that there's a high registration number, there might not be another third lottery, but no one knows. If again the filings continue to be low in this lottery pick as well, then you might well see a third lottery. And it's not unusual. We've had 3 lotteries before, so you can never say. Let's see what happens. Next slide. Also, before I go into the next topic, which is alternatives to H-1B, I wanted to briefly talk about continue to talk about the second cap, the second lottery. The terms and conditions for filing a H1 under the second lottery remain exactly the same as the first lottery. You have to file in the designated service center, which is mentioned in the registration document. You have to submit your registration document, meaning the approval, the lottery approval document that USCIS sends out, saying that your registration has been picked. So you have to submit that, follow instructions in that, and send it out to that service center. Don't follow the service center addresses on the website because that will not be correct. Also, you have to send out send out the right fee. You have to send out your educational credentials. You have to send out if you are changing a status from an F1 or a H4. You have to send out proof of status. You have to show that you're in status in order for them to approve the change of status. And of course, you have to send out your passport copy. If there's any issues with reference to mismatching of information that you put into the registration document and the H-1B form, the I-129 form, you have to submit an explanation and documentation to show why there's a mismatch. Sometimes the beneficiary's name may be incorrect in your registration. You made a mistake, typographical error, company name, there might be a typographical error there. Also, maybe you put in the wrong passport number, etc., etc. Another quick pointer for the lottery, the second lottery, is make sure if you have gotten an approval under the master's cap, that then you have to put in your master's degree. You have to show that it is from a non-profit or public university, public organization. So, and submit, of course, your master's degree. So that's very important. If your degree is not completed as yet, you have to submit a letter showing that you have completed all the requirements towards the degree. So yeah, so make sure that you have all the information that you need before you submit the H1. Most importantly, make sure you have the right fee and send it to the right address, otherwise your application will come back. And then you may not have enough time to resubmit it because the 90 days might get over. Which leads me to another quick pointer. The earlier you submit, the better, because if there are any issues, then you can correct them and resubmit. If you submit in advance, if you submit in the last minute, then you won't have the opportunity of doing that. Okay, then. So now since we've spoken a little bit about the second lottery, let's go into now that, say there's no other lottery, then we have to think about what are the alternatives. If there's someone that wants to come in before this next cap opens up, which we know will be in March, and you'll be able to file a petition, and then it'll only get approved in October. So say the employer requires the person to come in before that. Are there any alternatives really if the H-1B numbers are unavailable? So one of the most important alternatives is if your employer is a cap exempt organization, then you're allowed to file a H-1B petition even when there's no cap. And who is cap exempt? Institutions of higher education. So if you're a university, a college, they are institutions of higher education, not schools, just colleges. Non-profit related or affiliated to a higher education institution. So, for example, if you're a hospital, like Cornell or some other hospital, that has an affiliation with the Cornell Medical School, then you, as an example, then you are still cap exempt. Or if you're a non-profit research organization or a governmental research organization, then also you are cap exempt. So those are some of the organizations who can still file H1s when the cap is over. Also, you have to keep in mind that, say you're a consulting company and your client is cap exempt, even then you can file a H-1B cap exempt petition. So that's a very important point to note. Client can be cap exempt as long as they're working for an organization that's cap exempt. Even if you, the consulting company, is not cap exempt, you can still file a cap exempt H-1B petition. Next slide. O visas and P visas. So these are extraordinary ability visas. Um, Obviously, not everyone has an extraordinary ability, so not everyone can file an O visa. But if you have an extraordinary ability in the sciences, arts, motion picture, education, business, athletics, sports, then you could qualify for this kind of petition. Your employer has to file the petition, and you have to show that you have an extraordinary ability in um, one of these subjects. So this is definitely um, a good option in lieu of the H-1B petition. In addition to being able to work yourself, you will also then qualify for EB1, which is the green card, EB1 category, which is of course the most sought after category because the visa numbers are usually best for in the EB1 category. So if you qualify, O1 is the best, but of course you have to meet the criteria, which is not easy because you have to show extraordinary ability. And of course there are various criteria in order to show extraordinary ability. You have to show that you received awards. You have to show that you're in the top of your field. You have to show recommendations from people who are top in the field saying that you are. So maybe you can show that you have been peer reviewed, or judges have judged you and said that you're the best in your field. So there are criteria which you have to meet, and if you do, then this is definitely a possibility. And also recently USCIS has clarified that people in the STEM field can apply for an O1, and they've given certain guidelines, meaning that they've explained what documentation can be provided if you're in the STEM field, because you may be, it's clear with reference to arts and sciences, but sometimes with reference to computer science, maybe it may not be that clear as to what documents can be provided. They've suggested many alternate documents to the ones that they already have, because, again, when I say already have, when we're talking about an artist, obviously they'll have awards and, they would have won prizes, which may not be applicable to a person in the STEM field, but the person in the STEM field might still be of extraordinary ability. So they've provided some options that can be presented in lieu of, what is already there in the regulation. So that's a whole topic for another day, but if you're interested, you should go to STEM O1 petitions, and you'll get more information on Google as well. Next slide. So L1 is another option for alternatives to H1, and this is quite a popular alternative. A lot of big companies use L1B more often than they use H1, in fact. But of course, to be qualified for an L1B, you have to meet certain criteria. There's also the L1A category. So in order to qualify for the L1, you have to show that you have a company in the US and in your home country, and you have to show that they're both related. You have to show that one is an affiliate or a subsidiary or a parent of the other. And also you have to show that the beneficiary worked, if it's an L1A, in an executive position for the past 1 year out of 3 years in that parent company or in that foreign company. And you also have to show that they will continue to work as an executive if it's an L1A, or in a specialty occupation if it's an L1B, in the US company as well. So there's a lot of documentation involved. And it's not just submitting a job description to show executive level work or specialty occupation work. There's a lot of documentation that has to be submitted to support the job description. And also, it doesn't help if your company is really small, because especially for an L1A, if you're doing manager or executive, in order to prove that you're a manager, you have to show that you're managing either a department, or you have to show you're managing employees. If you're managing employees, then if you only are a one employee company, then it's difficult to show that you qualify for an L1A managerial level position. So there's some challenges to this, but it's something that a lot of companies file. So definitely look into this if you have employees that you need to bring into the country while with the H-1B numbers being over. And also L1 is a better option because there's no cap. So even if the H-1B season is upon you, you never know whether the registration will be accepted or not. We just talked about the low acceptance rate. So all these alternatives to H1 are important to keep in mind so that you don't have to depend on that H-1B lottery system as much as you otherwise would have to. Next slide. The other great option for Mexican and Canadian nationals is the TN. The TN is basically very simple because you can, if you're in Canada, you can actually just go to the port of entry and apply for a TN. You have to show that there are designated occupations, and which you can find on Google for TNs, which is published by NAFTA. And as long as you are within those designated occupations, you're working within those designated occupation, and you have the qualifications for that occupation, which is again given in that list, you should be able to file for a TN. If it's Mexico, then you have to actually go to the consulate and apply there. If it's Canada, you can just go to the port of entry and apply at the border. Or if you're coming by road, or just apply at the airport. CBP if you're coming by plane. So it becomes very easy. Once you're in the US on a TN, if you want, you can also file an extension or a transfer, in which case then you'll have to apply with USCIS, and then the process is a little lengthier, but not difficult. So definitely employers, if you are looking to enhance your numbers, if you're looking to hire more people, look to Canada and Mexico. Next slide. There are other alternatives as well. E3 is a great option if you're from Australia. And it's very similar to the H1 in the sense that you have to qualify in the same way that you would qualify for a H1, but you have to submit the petition at the consulate, and you have to file an LCA and submit a petitioner letter and submit your education credentials. The qualifications are same as H1, so you have to prove that the position is a specialty occupation and that you qualify for the position. So again, very simple. E3 visas. Again, Australia is a great resource. Australian nationals are a great resource for you to augment your numbers. So that's great. Also, the other one is H-1B1. There is a cap for H-1B1, but it doesn't usually get filled. Again, this is for nationals of Singapore and Chile. It's similar to the H-1B process. Another great option. Next slide. This is the E1 and E2 treaty trader and treaty investor visa. So if you are from designated country which the US allows to file E1 and E2. Again, this you can find on the internet as to whether your country, you're a national of a country that is qualifies for an E1 or an E2. An E1 is a treaty trader, E2 is a treaty investor. So you can bring in your employees if you are investing in the US, or you can bring in yourselves as the owners of the company. And again, there are certain requirements. You have to show that the money that you invested all came from your country of origin. You have to show that all the money is being used towards your business. And you have to show that you've invested enough money to support whatever business that you're doing. So, as long as you do all this, the person who comes in is work authorized, and the dependents of an E1 also are allowed to work. So that's great. So this is another great option for people who belong to those designated countries. And also, it's a great way of starting your own business, just like the L1. Next slide. F1, of course, we shouldn't forget. A lot of students use this. The F1 allows you to work after your degree for 1 year on OPT, and then an additional 2 years if you belong to a STEM program. If you've done your degree in a STEM program, gives you another 2 years of optional practical training. So you get a total of 3 years of optional practical training. So if you've missed the lottery, if you had bad luck and you didn't get selected, then you can always use your OPT and continue working. There's also something called CPT, which is curricular practical training, which is usually granted while you're still working. So if you want to work, but you're still going to school, then this is a great option, the CPT. So these are other options for students, and they use them really well, and they use them quite a lot because students don't always get picked. Their H1 doesn't always get picked in their first attempt. Next slide. And this is a great option, filing the green card directly, maybe while you're on F1 or while you're outside the country. This is a great option for people other than India and China who have backlogs. So if you don't belong to India, China, if you're born in some other country, even if you're, from India but born somewhere else, it might not be a bad idea to come on a green card directly, file an employment-based green card, and reduce your dependency on the H1, not use the H1, but come directly on a green card. If you have immediate relative families, you can also, make use of that and come directly on the green card and then work indefinitely and stay indefinitely in the US. Next. I think we're close to being done.
Yeah. So now shall we open it for the Q&A?
Sure, sure.
Great. Okay, so just a reminder for everyone, we already have quite a few questions here, but if you have any questions, please leave them in chat column and we'll be happy to pick it up. And please make sure that you're leaving all your question in one single message. Thank you. I'll go right on the top. What are the best options for H4 visa holders who don't have an EAD to have a work visa quicker than other H-1Bs?
Let me just go myself to the chat also. So best options for H4 visa holders who don't have an EAD to have a work visa quicker other than H-1B. So if you're on a H4, if you don't have a H4 EAD, you have to wait until your spouse files an I-140 and gets it approved so that you can get a EAD on a H4. and then you can once your spouse qualifies, then you can file for the H4 along with your spouse. That way, you file the H4, you file the H4 EAD, your spouse files the H1, and you get everything. Everybody gets it on this at the same time. And if your spouse is premium processing, then even better, you get your H4 EAD in 30 days. Otherwise, it's a long wait if you file it separately. But if you don't have an EAD and you can't go on a H1, then I've already given you the alternatives of what possible visas you can apply for and change your status from a H4 to either an F1 and work on CPT or work on OPT, or O if you qualify for an O, etc., etc.
Okay. So I'll move to the next one. This is easily one of the most common questions ever asked in our webinars. Can we apply through multiple employers? Let's say it is picked up from 2 employers. Can we still go through?
Yes, because a beneficiary is allowed to apply through different employers. Of course, there's a requirement that, the job offer be genuine. It can't be speculative registration. But other than that, if you have a job through both the employers, you can choose which one you want to go with. If both get picked, or if one gets picked, then you can go with that one that gets picked. So there's no issue with multiple registrations in the context of the beneficiary filing multiple registration. There's only an issue if the employer colludes with other companies and files multiple registrations for the same beneficiary.
Noted. Next question on the similar lines. I have filed through multiple employers and H-1B got picked up through one employer. Can I go ahead with the process? What are documents required if we submit it through multiple employers?
Well, yes, you can go ahead with the process as I just explained. If you go ahead with multiple employers, and if say you get an RFE and they allege that the employer colluded, then you have to prove that the employer did not collude and that they don't even know each other, but you submitted through your contacts to different employers. It also helps to show that it was a different job offer and everybody had their own job offers. That will help as well to show that there was no collusion. So if you can submit or gather documents to that effect, then that will really help.
Okay, thanks. Next up is my H-1B visa got revoked. If it is possible to transfer for another employer.
If your H-1B visa got revoked, again, if it's already revoked, then you might already be out of status. If it's a notice of intent to revoke or deny, then you might have the time while the petition is still pending, or the revocation notice, if it has not yet come in, then you might have the chance of filing a H-1B transfer or change of status to some other status so that you can continue to stay in the country.
There you go. Next up is my H1 got picked up in the second lottery, and my company said they are currently doing a posting for recruitment before filing for I-129. Just wondering if posting for recruitment needed for first-time H1 filing.
Posting for recruit. So basically, they have to put it on their website, but there is no time. There is no particular period of time that they have to wait or get resumes. It's not like a green card, but you have to put the requirement on your website or show that you attempted to recruit US citizens, but there's no time period within which you have to wait. And only after that file the H1. But there is an LCA requirement. LCA takes 5 to 7 business days, and you have to post the LCA so that all your employees can see it. But that's the extent of the recruitment process required for H-1B dependent employers. That means if they have a certain number of employees on H1, then they have to do that recruitment. But again, there's no time frame that they have to wait for before they have to actually file the H1.
Okay, I think there's a continuation from the same person, so I'll read this out to you first. So my passport expires in August 2024, which would leave close to 8 months of validity when I go to India for stamping in January. What should I do in this scenario? Wait for the stamping and then apply for a passport renewal? Is that going to be an issue when I go for stamping, or renew my passport now and then apply for H1 filing?
I think you should renew your passport now and then go for a visa. Because if you go for a visa before and your passport expires in 8 months, most probably they will only grant you well, they might grant you the visa for 3 years, but when you come into the country, they'll grant you entry in the I-94 only for the duration of the passport. So that is, it's always a problem when you're traveling. It's always good to have a passport that is not expiring in the near future.
I hope you get your answer there. Next question is, my STEM OPT expires April 6, 2024. If my H-1B gets picked up next year during March 2024 lottery, would the timeline make me out of status before I get the receipt for the picked H-1B?
Yeah, because you'll have 60 days grace period. So that will take you to May, June, but your H1, remember, new H1s only start in October. So there might be a gap, but we have the gap rule. So if you are in status as of the date of filing your H1, then that status continues until October 1st. So the gap rule will help you there. So, as long as you're able to avail of it, then you will not be out of status.
Okay. Next question is, can we file EB1 on J1 visa and later travel with I-140 approved and come back?
Well, you have to qualify for an EB1. People seem to think that it's easy to file an EB1. Everyone asks me, I want to file my EB1. Yes, you do, but do you qualify? Only a very few select people qualify for an EB1. So if you do, then there is, with the problem with the J1 is there may be a condition to go back to the country for 2 years and come back. So it depends on what type of J1 you're filing. If there is such a condition, then you'll have to file a waiver. And once the waiver is approved, then you can change your status to a H1, file a green card, etc. I don't know why you need an I-140 to travel. An I-140 has nothing to do with traveling. You would travel on a J1. So the other thing is J1 might have something called the intent to immigrate. I have to look it up, but I think if J1 doesn't have dual intent, then that could be a problem traveling if you filed your I-140. So H1 doesn't have an intent issue. You can have a dual intent, which means you can file your I-140 and then travel after the I-140 is approved. So you can have the intent to immigrate. So, if the J1 doesn't have the intent to immigrate, then you can travel. But I also told you that there's some other issues, so keep those in mind as well.
Okay. Prashanthi, the same person just dropped a couple of other texts. Home return, and the other one says, will there be question of POE?
Home return? Sorry?
Yeah, I guess this person must be giving more information to what you were mentioning. So maybe we will just, so this is a good case where we would certainly need more information. So what you can do is you can reach out to us and we'd be happy to schedule a one-on-one.
Right. So let's try to answer one question for each person.
Right. Yeah,
So we can, fairly
Mhm.
go to
Yeah,
every person.
absolutely. Next question is, what are the work permit options available to a professional from a field outside of STEM program? Example, law. Is H-1B cap exempt slash H-4 EAD the only option?
So H1 is not only for a STEM program, it's for any job that requires a bachelor's in a specific field. So law absolutely qualifies, but in order to file as an attorney, you have to be licensed because the job requires an attorney has to be licensed. Example, accountant, same thing, you have to be licensed. If you're filing as a CPA, if you're filing as an accountant, then you may not need to be. So as long as you meet the licensing requirements, you should be able to file as an attorney. There's no cap exempt because you're filing for as an attorney. It's not cap exempt. I've already mentioned who comes under cap exempt. Of course, if you previously filed a H1 in the last 6 years, then you're cap exempt automatically because you've already been counted towards a cap. So H4D EAD is not the only option. You have H1B as an option also.
Okay. Next question is, can we get a H-4 EAD while the I-140 is not approved for H-1B? Can we get a L-1 visa while in US with a H-4 visa?
So you can't get H4 EAD unless the I-140 is actually approved. And you can get an L1 visa as long as you have worked as an executive or manager or specialty occupation with the parent, with the foreign company for 1 year out of the last 3 years. 1 year out of the last 3 years. If you're presently on a H4 and you've been on a H1 for the last 3 years, then obviously you won't qualify. So 1 out of the last 3 years, you should have worked for the foreign company. Then you can, even if you're here on a H4, you can file a change of status.
All right. So we have about 15 minutes left, so I'll quickly rush through the remaining questions here. And if you're not able to pick up your question now, don't worry, you will have an opportunity to schedule a one-on-one session as well. I got selected in H-1B lottery, but not filed for my transfer from H-4 EAD to H-1B now.
You got selected in the lottery, but did not file for transfer. So what's the question there? I don't see the question.
That's that. Now
Let's go
and
to the
then
next
question
one.
mark.
Yeah, next
Okay.
one.
Yeah. So again, a good case. You can reach out to us, and we'd be happy to help. This question. Can I start I-140 process while I am still on OPT?
Yes, you can. But remember, F1 is not dual intent. So if you are traveling on an F1 and you have an I-140 approved, they might not let you back into the country. If you're filing for an OPT or an F1 or an extension or transfer of school, anything with USCIS, there is a question if you've ever filed an immigrant petition on the I-539 form. So that might trigger, and USCIS might not approve the petition that you're filing. So F1 doesn't have a dual intent. If you're not doing anything on the F1, not traveling, not applying to USCIS, then you should be okay.
Okay. H4 got picked in the lottery. Can they apply for the H-1B?
H4 got picked in the lottery. You mean H1 got picked in the lottery?
No, I think, yeah, there's a typo there, I guess, then.
H1B got picked in the lottery, and what's the question?
Well, the original question was H4 got picked in the lottery. Can they apply for the H-1B?
I
Maybe
think
there's a
that
typo.
let's go to the
Yeah.
next one.
All right,
Yeah.
we'll move on to the next one. Submitted H-1B through multiple employers, and H-1B got picked up through one employer. If other employers are not able to provide job offers, what are the consequences? Will it be an IOD?
We can't say. I mean, it's not necessary that it will be, or even if there will be an RFE. But if there is one, as I said, you have to show that, there are distinct job offers. That when they filed a registration, there was a legitimate job offer, and they were not just filing the registration speculatively. It's difficult to say. It really depends on whether there is an RFE or not, what they ask in the RFE. But it definitely makes sense to have that information in hand, just just in case they ask for it. And because if you don't have it, they might deny the case. So, I don't think, it's unlikely there'll be a fraud investigation if it's a one-off, because they're going after companies who are doing this for multiple cases. But the only thing is you have to safeguard your status and make sure you're still in status if the case gets denied, worst case scenario.
Okay. Is there a status update on the pilot program to secure a US visa stamping here in US?
Not yet. They said that they are definitely going to implement it and they're working on it.
Okay. Next one is a slightly longer one, so please bear with me. My H-1B got approved in the first lottery. I applied from multiple companies, but there was no relation with companies I applied, and the company, my H-1B got approved. My question is, can I get my H-1B visa stamped now by visiting Canada? Is it risky now or should I wait? Question 2, my STEM OPT expires in June 2024. If I go to Canada for H-1B stamping before my H-1B gets started, that is before October 1st, and if it gets rejected, should I be able to enter USA with STEM OPT visa?
Right. I applied, first question, I would wait before you go for stamping to Canada, because there's a lot of uncertainty, and the USCIS interpretation of this is in a state of flux. There are court cases being filed. So if you're not in a rush to go for a visa stamping, don't go now. Go after everything is settled, and there's also new law coming up. I think USCIS has said that they intend to make it clear before the next registration season, which is in March of next year, what can be and cannot be done. So I would just wait until everything's, the dust settles if you're not in a rush. With reference to the second question, you can only go to Canada 10 days before the validity of your H1 is going to start. You can't go earlier than that. So I think your question is moot with reference to that. But if you go, so you can go 10 days before. And if it gets rejected, then if you're going for the purposes of a visa, then they won't allow you back on your OPT or H1 or whatever it is. But if you're just going for a visit, they'll allow you back. So that's the catch there. They'll allow you back without a visa from Canada to the US.
Okay. Next up is, I stayed in US for 4 years, 6 months using both H1, that is for 2 years and 10 months, and L1B 20 months, L1B for 20 months. Can I recapture 3 years, 2 months using H1, or will it be just 1.5 years when I want to switch to H1 from L1?
So you have to calculate the time spent on L1 and the time spent on H1, and then see how much time you have left. And in this case, you should be cap exempt as well, as long as you worked in the US within the last 6 years.
Okay, all right. And for the interest of time, we will be picking up one question per user. So if you have more than one question, we would request you to schedule a consultation session, just for the interest of time and to answer everyone else. Just going through the questions. In the lottery, H-1B got selected. Presently, my visa is H4. I am in USA for the last 6 months. Can I file my petition, which got picked in the lottery?
H1 got selected, presently on H4. I don't see why not. You can file a change of status. Yes, you can.
Okay. And the final one as of now is submitted H-1B through multiple employers, 15. H-1B got picked in first lottery and didn't file, and it got picked up in second lottery. I don't have a proof to show any job offers. How can we show proof if we get RFE on multiple registrations?
Depends on what they ask in the RFE. They might also ask if there's any collusion, in which case your employer will have to show that there's no collusion and submit whatever documentation they can, or an affidavit. There's definitely a requirement that there should be a valid job offer for registration, that the registration cannot be, again, speculative. So if they do ask, then you might be out of luck, or you'll have to argue that, that's not the law. It's because, some of these things, this law with reference to collusion, if yours was filed last year, then you could have argued that, there was no, the law was not actually published, so it's not actually law, and you don't have to follow it. But in this case, they did publish it. So I don't know how you can, if you don't have valid job offers, and if they actually ask that question, how you would overcome it. You might have a problem overcoming it.
Okay.
But I mean, just because the other thing is, just because you're not able to get the job offer letters from the employers doesn't mean that you didn't have a job offer, because employers may not be willing to give you documentation. Why will they give you documentation if you're not joining them? So that could be your argument, and there, you could file. I mean, there are court cases being filed by beneficiaries just like yours who are innocent, and have, no control of the situation. So you could do the same and join one of those, join one of those court cases, and hopefully things will get resolved by the time you get your RFE.
All right. I hope that answers your question. Well, that wraps up our Q&A. So on that note, Prashanthi, I thank you so very much for giving us this insightful session. And yeah, we look forward to the next webinar soon.
Thank you, Vishal, and thank you all for joining the webinar, and stay tuned for the next one.